I'm Daniel Malakauskas of Malakauskas Law, and today I'll be giving an overview of acquiring U.S. citizenship through marriage. Please note that this video only covers the process after you have already acquired permanent residency. It does not explain the permanent residency process at all. So let's begin. First off, what is U.S. citizenship through marriage? U.S. citizenship through marriage is the process by which an individual gains U.S. citizenship by being married to a U.S. citizen. Often, when a U.S. citizen finds their spouse outside of the United States, their ultimate goal is to bring their spouse into the United States where the couple can live a happy life. Gaining U.S. citizenship saves the couple from ever having to worry about a spouse being deported. What is the difference between U.S. citizenship through marriage and U.S. citizenship through naturalization? Although technically both are considered U.S. citizenship through naturalization, U.S. citizenship through marriage is the process that an individual obtains U.S. citizenship through the requirements of 8 U.S. Code 1430. And citizenship through naturalization is the process that an individual gains citizenship through the requirements of 8 U.S. Code 1427. For U.S. citizenship through marriage, the main difference is that an individual must be married to acquire U.S. citizenship. In exchange for being married to a U.S. citizen, an individual is granted a shorter waiting period to apply for citizenship. By contrast, U.S. citizenship through naturalization does not require that an individual be married to a U.S. citizen. However, since they are not required to be married to a U.S. citizen, they are given the extra burden of having a longer waiting period to apply. What are the requirements for citizenship through marriage? Generally, in order to qualify for U.S. citizenship through marriage, there are 3 main requirements. Number 1, you must be married to a U.S. citizen. Number 2, you must have been a continuous resident and been physically present within the United States for a certain amount of time. And number 3, you must not have a serious criminal record or have engaged in other acts deemed disqualifying by the United States government. In addition, your marriage will be carefully scrutinized. You will be required to prove that your marriage is actually genuine. Your relationship will be examined in thorough detail. Can you still obtain U.S. citizenship if you are no longer married to a U.S. citizen? Yes, even if you are no longer married, provided you obtained your U.S. permanent residency through marriage, you can still obtain your U.S. citizenship. However, you will no longer be able to obtain U.S. citizenship through 8 United States Code 1430. Instead, you will need to obtain U.S. citizenship through 8 United States Code 1427. The major difference will be that you will now have a longer waiting period of 5 years as opposed to the shorter waiting period of 3 years. Therefore, if you got a divorce, the path to getting United States citizenship will be slightly longer. In addition, even though you are no longer married, you still will be required to show or prove that your marriage was actually genuine. You will have to prove that it was a real marriage. In addition, you will have to show proof of the divorce from your spouse or the death of your spouse. What if your spouse is abusive? Do you have to stay married to obtain U.S. citizenship? No. If you have an abusive spouse, you may apply for citizenship under VAWA, also known as the Violence Against Women's Act or the Violence Against Immigrants Act. To qualify under VAWA, number 1, you must be a victim of abuse. Number 2, the person who hurt you must be a U.S. citizen or permanent resident. And 3, you must have suffered battery or extreme cruelty at their hands. What documents are required for U.S. citizenship through marriage? The supporting documents you will need for your application depend upon your specific situation. However, common supporting documents often include, but are not limited to, first, the application itself for naturalization, known as Form N-400, copies of your permanent resident card, your marriage certificate, evidence that your marriage is genuine or legitimate, proof of death or divorce from previous marriages of both you and your spouse's birth certificate or naturalization or certificate of citizenship, your passport or other entry documents, your selective service registration if you are a male, passport photographs, financial records, tax records, criminal records. However, not all these documents will be required in every application. In addition, your circumstances may require different or unique documentation. How do I start the U.S. citizenship through marriage process? Assuming you are already married to a United States citizen and you have already acquired your permanent residency, you will start the process by filing an application with the United States Citizens and Immigration Service. The application is entitled Application for Naturalization. The application is filed online. However, if you would like a paper application, the paper application is known as Application for Naturalization or Form N-400. What if I am facing financial hardship? Can I still apply? If you are facing financial hardship, you may still apply for your United States citizenship. You may file for a request for a fee waiver. The fee waiver form must be submitted with your application. The form is known as Form I-912. What happens after you file the application for citizenship through marriage? After you file your application, the United States Citizens and Immigration Service will either 1, send you a notice informing you that you must attend an interview, or 2, send you an N-14 form requesting that you provide more information with your application. Your interview will consist of several components. Number 1, you will have questions about your marriage, your background, and your previous actions while inside and potentially outside of the United States. Number 2, you'll be required to pass an English examination. And number 3, you'll be required to pass a civics examination. Does U.S. citizenship through marriage require English proficiency? Yes. In order to obtain U.S. citizenship through marriage, you'll be required to read, write, and speak basic English. As part of the process, you'll be required to read and write 1 out of 3 sentences correctly. You should take learning English very seriously. Failing the English examination is one of the top or leading causes of having your citizenship application denied. What is the civics exam that U.S. citizenship through marriage applicants must take? During your interview with the United States Citizens and Immigration Service, you will be required to take and pass a civics exam. The current 2025 naturalization civics exam is an oral test that consists of 20 questions. The 20 questions are randomly selected from a list of 128 questions. You will be required to answer 12 out of the 20 questions correctly. However, since your citizenship is at stake, you should take the civics exam seriously and study all 128 questions. Why fail because you were unprepared? What happens after your interview for U.S. citizenship through marriage? After you have attended your interview, United States Citizens and Immigration Service should issue a decision within 120 days. In response to the interview, you may receive a form entitled Naturalization Interview Results, also known as Form N-652. If you receive Form N-652, you may be informed that you have successfully obtained citizenship. However, Form N-652 can also tell you that there is a deficiency in your application. For example, it may tell you that you have failed the civics exam, but usually you are given another opportunity. Or you may be informed that a decision on your application cannot be made due to insufficient information. It may then request additional information. Regardless, receiving Form N-652 generally means that your application was not outright denied. What happens if your citizenship through marriage application is denied? If your application is denied, you may request for a hearing. To request a hearing, you file a document entitled Request for a Hearing on a Decision in Naturalization Proceedings under Section 336. The request must be filed within 30 days of receiving the decision or within 33 days if you received the decision by mail. After filing your request, you will be scheduled a hearing. After the hearing, should your application be denied yet again, you will be allowed to appeal your application in federal district court. Thank you for watching. Please like or subscribe. If you have any questions or would like future topics in these videos, please leave a comment below. Finally, please note that this video was for informational purposes only and does not constitute legal advice. In addition, this video was simply a brief overview. Remember, the devil is often in the details. Therefore, you will need an attorney to evaluate your individual situation or conduct your own thorough research. Thank you again.